Hello. Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is an attorney, Michael Demaray, and Michael practices law in Los Gatos, California. He's a California attorney and principally works in the area of litigation or lawsuits related to estates and trusts. And he's been practicing law for about 35 years. Originally went to UC Davis and graduated from Hastings Law School. And I can tell you, Mike is highly respected in the community. I'm actually very pleased to have him as a guest today. So thank you, Michael, for being with me today.
My pleasure, Mike. Can I say hi to my girlfriend?
Go ahead. What the heck?
Hi, Jeannie.
There you go.
Can I say hi to my wife now? No, I'm just kidding.
Okay, thanks. Smart ass. Okay. So anyway, so today actually our topic is going to be talking about beneficiary rights. And beneficiary rights can vary a little bit from state to state. So I would just want to alert you that Michael is a California attorney. I'm a California CPA. So that's the areas that we're most familiar with. And so this is to be a beginning of another conversation that you may have with your own attorney, and certainly that's what we would recommend. So with that, Michael, let's get into it a little bit here. Okay, so let's say a close relative died, and so I'm a relation. How can I find out if I have an inheritance?
Well, first, Mike, if you were a teenager, I'd tell you to stand on your own 2 feet, get a job, and quit looking for money from other people. But basically, assuming you're not a teenager anymore,
Okay, right.
there are 2 ways to find out about it. The probate code requires that if there's a will, it has to be filed with the county courthouse of the county in which the decedent was a resident when he died within 30 days. And you could simply go down to the county courthouse, ask for help from a court clerk, and look up to see if there was a will that had been filed. If there is a trust, a living trust, which is what we commonly call them now, the trustee has a duty within 30 days after death to mail a notification to everybody that is a beneficiary of the trust and the people who would inherit property from the decedent if there was no trust. We call them heirs.
Okay.
You might say, well, why would you give notice to people that aren't beneficiaries? The reason being that the heirs are supposed to receive notice in case they want to contest the terms of the trust. A will is not self-proving in California. In other words, you have to petition to admit it to probate. That's generally when most people will find out if they're the beneficiary under a will, because they'll get a notice in the mail stating that the person is petitioning to admit the will to probate. But on a trust, if the trustee isn't doing his job, there aren't a whole lot of ways that you can find out except to initiate your own probate action. That will usually bring out an answer in terms of who has actually got the will or the trust and what they're going to do about it. If you don't want to do these kinds of things yourself, you can hire what are frequently called heir hunters. But by the time you get around to reading the fine print, you'll find out that in return for them finding out if you're a beneficiary, you've assigned them 50% of the estate. Now, there's a probate code section that's supposed to enable the court to prevent them from overcharging you. But by and large, you spend a lot more money if you have somebody else try to look up these things for you.
Okay. So I think then you've just explained pretty much what the notices are that are required. Now let's say I had a single mother, in other words, father's passed away or whatever. And so she died a year ago, and I believe my brother is the trustee. I haven't heard or seen anything happen for the administration of her trust. What can I do to get things moving? And what if my mother, then I guess the second question in a sense related to that follow-up is, what if my mother remarried and my stepfather is the trustee? Oh boy, that makes it be more fun, doesn't it?
It's awkward because you're at the funeral and often the occasion will not arise for you to tactfully ask, gee, is there going to be any probate or anything like that? And if you don't want to do that, but you want to find out, as I said, within 30 days you're supposed to get some type of notification. But let's just say for the sake of argument that the stepfather doesn't give you the notification you're entitled to. and you want to find out, then what you could start is your own probate. You go down to the courthouse, you file a petition to appoint yourself as the administrator of the estate on the grounds that you know of no will. And generally that'll not generally, you'll have to give notice to the stepfather, and when he gets that notice, you can bet your bottom dollar he'll wind up doing something. You might say, well, gee, doesn't that require me to hire a lawyer? Generally speaking, it does. But if you're that interested in finding out, that's the only way you can basically force the issue.
Okay. All right. Here's an interesting one. If I'm a beneficiary of a will or a trust, and it has a no contest clause, does that mean that I'm shut out or I can't challenge the will or trust? What should I do in that case?
Well, a no contest clause has been around for a long time. But the essence of why a no contest clause works is that it's only a threat to you if the will or trust leaves you something. In other words, if you don't get anything under the will or the trust, you might as well go ahead and try to contest it on the grounds that, well, I'm not going to get anything anyway, and the fact that the no contest clause says that if I try to break the will, I don't get anything doesn't mean anything. So the no contest clause is really only a threat if the will or the trust leaves you something, and leaves you something significant. In other words, if it left you $5,000, that might not defer much anyone. But if it left you $100,000 or $1 million, you might think twice about contesting a will, where if you failed to successfully contest it, you'd lose the $1 million. Now, if you did successfully contest it, then you still get half or all of the estate, depending upon what the prior will or trust or the laws of intestate succession say you get. Also, there's been some changes, Mike, in the law with respect to no contest clauses. Now, if there was probable cause for your contest, with a couple of exceptions, you still don't violate the no contest clause. Of course, the question is whether or not you had probable cause for what you filed, and there's really no way to know that anymore in advance of the proceeding.
Right. Now, related to this stuff, isn't there something where basically you can ask a court if what you do is going to trip you up?
It's called a safe harbor application. In the, quote, old days, close quote, and I mean, you can go back decades, there was either a civil proceeding you could bring or a probate code petition you could bring called a safe harbor petition, where you'd say to the court, Judge, I want to file this action over here, but I want to be sure that this type of action doesn't violate the no contest clause. And then if the judge says, no, if you file that, it would violate the no contest clause, well, you haven't violated the no contest clause simply by asking the court for permission to do that. That, however, is not the law anymore. You no longer have a safe harbor application.
Oh, there isn't.
Again, if you're going to contest the will, that's going to be a contest no matter what you do. But sometimes you'll say, gee, I want to find out if a certain property was community property or separate property. I want to remove somebody as the trustee. I want to compel the trustee to do an accounting. Or I simply want to ask the court what this will or this particular provision in the will means. Those are kinds of things that some no contest clauses might prescribe and others might not, but the bottom line is you can't find out ahead of time whether you violated the no contest clause because that safe harbor application is no longer available to you.
What do you do? Just take a chance?